It's 9 o'clock on the dot, and Sarah's standing at her mom's kitchen counter with a folder that says will in black marker. Her mom died last week. Sarah did what most responsible family members do. She found the will, called the bank, and tried to pay the mortgage so the house wouldn't fall behind. And the bank rep says, "I'm sorry, we can't talk to you. The account is frozen." Sarah says, "But I'm in the will." And the rep says a sentence that starts 1,000 probate nightmares. You'll need letters from the court. In a minute, I'll show you the exact reason a family can do everything right, have a will, and still end up in probate anyway. This is video number 3 in my 5 Critical Documents estate planning series for adults in the U.S. Today is the standard traditional will, the one most people have heard of. By the end of this video, you'll know what a will does in plain English, what it doesn't do, and this is where people get burned, what intestate really means. And we'll also look at a few sample scenarios where families thought they were covered and still landed in probate court. A standard will is basically your written instructions after you die. The will declares a person's wishes for their estate post death. Most wills answer 4 things: who gets what, who's in charge, your executor or your personal representative. It lists the guardians for your minor kids. That's huge for parents. And also any special instructions for personal items, charity, etc. So, yes, wills matter. But here's where people get blindsided. A will doesn't act like a magic key that unlocks your accounts. A will usually has to be accepted by the court first, and that court process is probate. So when our friend Sarah, her mom passed, and she hears you need letters from the court, it's not about the bank being rude. That's the bank saying we need legal proof that the court has officially authorized someone to act. The permission slip from the court is the probate process. So, next, I'm going to walk you through 5 sample situations that put families in probate, even with a will. And in scenario 5, you'll see the exact kind of wording that turns grieving siblings into courtroom enemies. In the first scenario, the family has a will, but legally it doesn't count. And there's several reasons this can happen. Those reasons include, but are not limited to, people using DIY templates that aren't executed correctly, forms that are missing witnesses or the wrong witnesses, or the forms are not notarized properly, pages that are not properly signed or initialed properly, handwritten edits after the paperwork has been signed, or there's a final version of the will that can't be found. And then your family finds out the hard way that the courts don't grade on effort. So instead of a simple process, the estate becomes a court process with possible hearings, delays, expensive extra costs, and sometimes a fight over whether the will is valid at all. In scenario 2, the will is totally valid and the family still loses control because the will gets outvoted by paperwork most people forget exists. In this scenario, the beneficiary forms say one thing and the will says another thing. This is one of the most common wait, what moments. Some assets follow the will, but a lot of the major assets follow beneficiary designations. Things like life insurance, IRA accounts, and payable on death bank accounts are based on beneficiary designations. So you'll fill out a form either digitally or manually and designate what beneficiaries you want and what percentage they'll get. If that form is outdated or it contradicts your will, Your will doesn't override it in many cases. So a parent will say, my will splits everything equally between my kids, but their retirement account still lists an ex spouse or just one child from 15 years ago. And suddenly the family is in probate, they're angry and they're confused, saying, that's not what mom would have wanted, or that's not what dad said. So remember this: beneficiary forms can control big money. If you're still with me, type big money in the comments. Also, as a rule of thumb, I always say that people can set a reminder on their cell phone annually that will reoccur about a week or two before your birthday to check your beneficiary designations. Depending on how many accounts you have, it may take you 20 or 30 minutes, or it may take you several hours, but it's worth it to keep everything calm in your family, to keep confusion down, and to hopefully keep your family out of court. The next scenario is the one that no one wants to talk about: blended families. And if you've got step kids and you say or think, my spouse will handle it fairly, that's where probate drama is born. So here's the sentence that sounds loving but can explode later: I'll leave everything to my spouse, trusting that they'll take care of my children. It sounds peaceful, doesn't it? Until the spouse remarries, the spouse gets pressured by their side of the family. Their relationship with the stepkids was never strong, or the spouse changes their own plan later. Then your kids from the first marriage feel erased, your spouse feels attacked, and the only place to settle it becomes court. In this scenario, clarity beats hope. Now, the next scenario is sneaky because it feels normal. You've got a cabin, a piece of land, maybe a vacation timeshare somewhere, and suddenly you're dealing with more than one probate process. So, in scenario 4, we've got someone with out of state property. Just for an example, we're going to say there are two states involved. So, even with a valid will, when you own real estate in another state, that can trigger extra legal steps. It's often called ancillary probate, ANCILLARY, because states control how property inside their borders transfers. So, in this scenario, your family isn't just grieving, they're coordinating between two courts, two sets of rules, more paperwork, and usually more cost. You've got two different states, which means two different systems. And for our last scenario, we're going back to our friend Sarah. This is where families discover the most dangerous thing in a will actually is not having a will at all, but it's a will that's vague. So our friend Sarah thinks her mom's will is valid. It's signed, it's witnessed, it's got any proper notary seals and dates. Everything's done. And Sarah thinks, okay, this will be straightforward. But there's one line in the will about the house. It says, I want my children to share the house fairly. Sarah reads that and thinks, sell it and split it. Her brother reads it and thinks, I've been living here. I should keep it. Her sister reads it and thinks, I want my share now. Pay me out. Now the mortgage is due. The house needs upkeep. Emotions are high. And fairly turns into, who decides the value of the home? Who pays the bills during probate? What if one sibling refuses to sign off? What if the executor is also one of the siblings? And this is how Sarah, who did everything right, ends up in probate court, fighting for her mom's estate, even though her mom had a will. So remember that vague wording can equal expensive conflict. So let's talk about a term that you may or may not have heard of: intestacy. Intestacy. Did you know that even if you pass away without a will, you already have a default will that was created for you by your state? It's called an intestate will. And when you have an intestate will, your state has a default plan for your life, like a one size fits all will that you didn't write. I grew up hearing my family members express concern over the state taking their homes, the state getting everything. And this is what they were referring to. I would think that most adults in the US want to avoid something like this, especially since an intestate will would determine who would care for your minor children, who gets your property, etc. You have to think about, do you want some random judge that you don't know determining this? I would guess the answer would be no for most people. So you say, DK, what can I do if I don't want the state deciding who inherits my property, who's in charge, how fast everything happens, and what happens to my kids? Then your goal is simple: three things. Number one, create a will that meets your state's rules. Number two, keep it updated after major life changes. And number three, make sure someone can find it. So now, time for a quick question, and you can answer me in the comments. Do you currently have a will? Put yes if so in the comments. If you don't have a will, what is your biggest obstacle to getting a will drafted? You can give me, one, two, or three words as your answer. Could it be money, confusion, legal jargon, emotional discomfort, all of the above? Let me know in the comments, because what's blocking you tells you the next step that you need to take. Next, I'm going to give you a completely simple starting point checklist, because the number one reason people don't do this is due to overwhelm. So, if you're feeling overwhelmed, that's completely normal. Most people aren't procrastinating because they don't care. They're stuck because legal language feels like a foreign language and the decisions feel heavy. So here's your plain English starting point. 4 steps for you. Number one, list your people. Who's important to you: your spouse, your partner, your kids, stepkids, your parents, in laws, anyone that's dependent on you. Number two, list your stuff: your home, any other property that's significant, your accounts, your retirement, life insurance, your vehicles, your business, crypto, digital assets. Number three, pick your in charge people, also sometimes called key contacts. You'll need executors, backups, you'll need guardians for minor kids and backups for those. And identify is number four in your process. Identify your risk level. Ask yourself, if I died this year, would my family agree or would they fight? So that answer is going to kind of give you a sense of urgency on, how much risk you have and how quickly you probably want to start looking into these different things. And if you need something that you can just easily fill in, I've got a digital planner called the Life Legacy List. It's over 100 pages, and it's a checklist and an organizer designed for U.S. adults who are either new to estate planning, or you started estate planning and you paused because you feel overwhelmed with the process and you got confused. This is something that can help you get back on track. You can print the Life Legacy List and manually complete it, or you can save it locally, complete it digitally, and password protect it on your own device. And because this is a brand new product launch, I'm doing a bump sale for a limited time. The price starts at $1 and it goes up $1 with each purchase. That means early adopters will get the best price, and every buyer still gets a huge discount compared to the value. Just to be clear, the life legacy list is not medical or legal advice. It's not a replacement for a formal will, a formal trust, or any other legal document. It's your starting point, your roadmap, and your organizer so you can move from a status of I'm lost to a status of I know what I have and I know what questions to ask. It's also a great tool because I do suggest when you do formal documents that you do contact some type of licensed legal professional to make sure everything's in line with your state. But we know that those professionals often work based on billable hours, and those hours are what you make of them. I've sat in on family members' estate planning meetings, and it really is what you make of them. You would probably prefer to go in with everything outlined and organized so you can get straight to what you need to do, as opposed to going in that hour trying to figure out what you need to do because you're going to be billed either way. So the life legacy list can have you armed up front. And again, it's starting at $1, going up $1 with each purchase. The link is in the description. So here's the truth. A will is essential, especially for naming an executor and guardians for kids. So you still need a will, but a will does not automatically keep your family out of probate. And vague wills can actually create fights. If you want to protect your family, aim for clarity, correct execution, updated beneficiaries, and aim for a plan that matches your family's reality. A lot of people think of a will as their entire estate plan or either the end of their estate plan. But you actually should think of the will as the beginning of your estate plan. And if you want to drastically reduce the chances that you end up in probate, number 4 coming up next in our series, the living trust is your best choice to avoid probate, but only if it's set up and maintained the right way. If you set up the living trust and miss a crucial second step, you can still end up in probate like one of my family members did. I told you I've learned a lot in this process. So if you're interested, hit like, subscribe, and hit that notification bell so you'll know as soon as number 4 in the series drops. And a quick reminder that the Life Legacy list is available starting at $1. Click the link in the description to get today's price. And check out this video that YouTube's recommending you watch next. Thanks for watching and see you next time.